Hello, I'm Pawan Thakur with Thakur Property Consultancy. For expert legal and property advice, you can reach me directly at 900-435-2787. In July 2024, the foundation of Indian criminal law changed. The 1973 Code of Criminal Procedure is completely gone, replaced entirely by the new Bhartiya Nagarik Suraksha Sanhita, or BNSS. While the sections have been renumbered, the code itself represents a structural overhaul of the Indian justice system. The BNSS moves the system away from a paper-based colonial framework and shifts it into a digitally native architecture. This shift changes three specific areas: police investigation powers, property search and seizure rules, and the hierarchy of the courts. For legal practitioners, corporate officers, and property consultants, the daily rules of operation have been rewritten. Technological evidence is no longer a secondary consideration. It is now the mandatory, statutory baseline. Ignoring this transition risks procedural failure in modern Indian criminal and property litigation. Every criminal case begins with the initiation pipeline, typically starting with a First Information Report, or FIR. Under the old 1973 code, filing an FIR was often restricted by the physical jurisdiction of the police station. Section 173 of the BNSS removes that barrier by granting absolute statutory recognition to the zero FIR. This means an FIR can now be legally registered at any police station, regardless of where the crime actually occurred. The statute also mandates the acceptance of EFIRs, allowing citizens to report crimes via electronic communication. However, there is a compliance catch. The EFIR must be physically signed within 3 days to remain legally actionable. Once a report is filed, the BNSS mandates a shift in how physical crime scenes are processed under Section 176. It is now a legal requirement for forensic experts to visit the crime scene and collect evidence for serious offenses. This threshold is triggered for any offense punishable by 7 years of imprisonment or more. To prevent arbitrary reports against public servants, Section 175 introduces a two-tier protection mechanism. First, the magistrate must receive a report from the official superior. Second, they must consider the accused official's assertions before ordering an investigation. To manage this workload, Section 20 formalizes the Directorate of Prosecution, designed to institutionalize prosecutorial accountability across the state and districts. These sections lower the barrier for citizens to report crimes, while simultaneously raising the scientific standard required for police to investigate them. We then move to the physical execution of police powers, searches, and property seizures. These laws are critical for anyone managing real estate or commercial property disputes where assets may be taken into custody. Section 105 of the BNSS introduces a groundbreaking technological requirement for these operations. The entire process of a search and seizure, including the seizure memo, must now be documented in real time via audio-video electronic means. If the police fail to record the seizure, it directly impacts whether that evidence can be admitted in court. There are also specific safeguards for the rights of the accused after detention, found in Section 38. An accused person has the statutory right to meet with an advocate during their interrogation. However, the Supreme Court has clarified that this right does not allow for the continuous presence of an advocate throughout the entire interrogation process. Procedural lapses in these digital documentation roles, like missing seizure videos, provide clear strategies for dismantling police cases before they ever reach trial. When a case reaches the adjudicatory phase, it enters a court system that has been structurally reorganized. Section 6 of the BNSS unifies the classes of criminal courts across India, removing localized variations. 2 roles have been deleted to create this uniform structure. First, the position of the Metropolitan Magistrate has been abolished. Second, the role of the Assistant Sessions Judge no longer exists. While the hierarchy is flatter, the fining and sentencing powers of the remaining magistrates have increased. A judicial magistrate first class can now impose fines up to 50,000 rupees, a 5-fold increase. The law also introduces a new sentencing option, community service. To address the court backlog, Section 283 significantly expands the scope of summary trials. Previously, fast-track summary trials were capped at cases involving property worth just 200 rupees. That limit has now been raised to 20,000 rupees. Magistrates also have the discretion to summarily try offenses punishable by up to 3 years of imprisonment. By widening this threshold, the BNSS pushes tens of thousands of pending property and theft cases into a rapid 5-step adjudication track. The final stage of the BNSS pipeline is the high-tech courtroom trial. Section 530 explicitly permits all trials, inquiries, and the recording of evidence to take place entirely in electronic mode. Portals like Nyaya Shruti have been implemented to standardize virtual appearances for witnesses, experts, and the accused. The code also addresses the historical problem of accused persons absconding to delay justice. There is now a formal mechanism for trials in absentia. If a proclaimed offender fails to appear before the court within 90 days of charges being framed, the trial proceeds without them. Evidence is weighed, and a conviction and sentence can now be legally passed in their physical absence. The BNSS of 2023 replaces a slow, paper-based methodology with a tech-enabled legal engine designed for speed and accountability. For corporate entities and real estate professionals, updating internal compliance and litigation strategies is now a necessity. Thank you for watching. For legal guidance, property disputes, or real estate consultancy, contact me, Pawan Talker, at 900-435-2787.